between the respective parties. Can I first address Your Honour ever so briefly on the cause and origin of the Good fire? And in my respectful submission, Your Honour will find that in respect of that particular fire, that all the evidence points generally in a single direction, and it is submitted that the Good fire originated in a remote area approximately 800 metres south of a property known as Rose Retreat at 2116 Durangle Road, Durangle, at the location of one tree or perhaps multiple trees in the vicinity of GPS coordinates latitude 35 degrees 56 minutes 14 seconds south and longitude 149 degrees 20 minutes 18 seconds east, and that the cause was one or more lightning strikes within a 48-hour period between the 27th and the 29th of December 2019. Coming now, if I may, Your Honour, into the inquest into the deaths of Rick De Morgan Jr., Paul Hudson and Ian Macbeth. By way of background, as Your Honour knows, on the 23rd of January 2020, Rick De Morgan Jr., Paul Hudson and Ian Macbeth were providing aerial support to combat the Good fire in the Snowy Monaro region. Moments after dropping retardant in strong winds, their large air tanker, or LAT, a Lockheed C-130 Hercules, call sign B134, was likely subject to a wind event. Tragically, the aircraft stalled and crashed, resulting in the deaths of Rick, Paul and Ian. Can I briefly remind Your Honour, in relation to each of those individuals, who they were and what they'd done throughout the course of their lives? Coming firstly to Rick De Morgan Jr., he was 43 years of age when he tragically passed. Rick came from a tight-knit family and had a close relationship with his sister Virginia. He lived in Florida in the United States of America and had 2 children. At the time of his death, Rick was a member of the United States Air Force. He had served for 24 years. For most of that time, Rick was a flight engineer. He served multiple deployments in Afghanistan and Iraq and had amassed over 4,000 flight hours. Many of those hours were in combat. Rick arrived in Australia in January of 2020. This was his first fire season. He was due to retire from the Air Force, that is the United States Air Force, in early 2020. Rick was the flight engineer on B134 on the 23rd of January 2020. Turning, if I may, Your Honour, to Paul Hudson. Paul was the co-pilot on B134. He was 42 years of age. He lived in Arizona with his wife Noreen, and Noreen describes Paul as always optimistic, positive and smiling. Paul was a career Marine. He went straight from high school into the US Naval Academy before joining the US Marine Corps, where he spent the next 20 years. Paul retired in August 2019 as a Lieutenant Colonel. He had amassed almost 1,744 hours of flying time. Paul started work in Australia in December of 2019. He was eager to learn. It was also his first fire season, but Coulson, Director of Flight Operations, described Paul's early performance as at the level of someone with already half a season of aerial firefighting behind them. And then turning lastly to Ian Macbeth. Ian was the pilot in command on the 23rd of January 2020. He was 45 years old and had just handed in his resignation. Ian lived in Great Falls, Montana with his wife Bodie and their 3 children. He loved to ski, kayak and backpack. Ian was a pilot in the Wyoming and then Montana Air Guard. He was deployed to Afghanistan and Iraq and rose to the rank of Lieutenant Colonel. Over his time in the military and after joining Coulson Aviation in 2014, Ian amassed over 4,000 hours of flight time. This included 994 air tanker drops. He had also accrued almost 1,617 flight hours as a navigator. The foundation, established in Ian's name, describes him as an individual who loved adventure, appreciated hard work, and respected the importance of duty. All led him into a life of service. Your Honour, Rick, Paul and Ian all worked for Coulson Aviation. Coulson is a private operator contracted by the National Aerial Firefighting Centre. Its contract with NFAC requires Coulson to provide services, including aerial firefighting, when required to do so by certain states or territories, including here in New South Wales. During the 2019-2020 bushfire season, the New South Wales Rural Fire Service engaged 38 privately owned and operated aircraft through NFAC. Your Honour, can I come now to deal with the manner of the three deaths to which Your Honour is concerned. In our respectful submission, the manner of Ian, Paul and Rick's deaths is uncontroversial. As Your Honour knows, the ATSB carried out a detailed investigation into the cause of the accident. The RFS and Coulson Aviation have informed Your Honour that they do not dispute the findings of the ATSB as to the cause of the accident. Subject to one matter which I'll come to now, can I say this? The ATSB found that after B134 completed a partial retardant drop and left turned, the aircraft was very likely subject to hazardous environmental conditions, including low-level wind shear and an increased tailwind component, and the aircraft's climb performance degraded. Subsequently, while at a low height and airspeed, it was likely the aircraft aerodynamically stalled, resulting in a collision with terrain. It was stated that the significant wind event that caused B134 to stall would be a rare event, unexpected outside of thunderstorm-type activity. Your Honour, that's the finding as contained within the ATSB investigation report, which is Exhibit 66. In the submissions filed by Coulson Aviation, there is an alternate proposition put in relation to what caused the aerodynamic stall. It may be, in my respectful submission, a distinction without a difference. Coulson submit, Your Honour, and this is contained in paragraph 15 of their written outline, that Your Honour would substitute reference to wind shear in the proposed findings contended by those assisting Your Honour at paragraph 47 of our outline with the words a sudden and significant increase in tailwind in lieu of the word wind shear. It is submitted by Coulson Aviation that that phrase captures more clearly and reflects more aptly the likely environmental factors that were encountered by B134, which caused the aerodynamic stall leading to the collision with terrain. In my respectful submission, Your Honour does not need to resolve the competing hypothesis as to whether the particular wind event was wind shear or was an increase in tailwind. In our respectful submission, Your Honour could simply find that the aerodynamic stall was caused by a sudden and significant wind event, therefore not having to resolve the competing hypothesis as to whether the words wind shear should be used or the words sudden and significant increase in tailwind. I should note, however, that the ATSB in its report does refer to wind shear and an increased tailwind component. In our respectful submission, and this is dealt with in paragraph 47 to which I've just referred a moment ago, that having regard to the formal findings that Your Honour is required to make under Section 81, that Your Honour would find in relation to the deaths concerning Rick, Paul and Ian, that each of them died on the 23rd of January 2020 at approximately 1:15 p.m. at 2311 Peakview Road, Peakview, after the aircraft on which they were occupants was likely affected by a sudden and significant wind event, entered an aerodynamic stall and collided with terrain whilst engaged in aerial firefighting efforts to assist the suppression of a fire known as the Good Fire. Each of those three individuals' death was unable to be ascertained by autopsy. Your Honour, there are a number of issues which were canvassed before Your Honour in March of this year and which are addressed by each of the parties in their written outlines. Can I say this, and this is not controversial, that the retasking of B134 to the Good Fireground did not follow New South Wales RFS Standard Operating Procedure. That particular tasking was undertaken without the involvement of the State Operations Controller, Major Incident Controller, Deputy Incident Controller or the State Air Desk. The Air Operations Manager, in our respectful submission, Mr Finstead, did not have authority to retask B134 without consultation from those relevant parties. Further, we submit the retasking of B134 was not communicated to those relevant parties after it occurred. Again, can I say, and this is dealt with in our written outline, a matter that is not in our submission controversial, is that the ultimate decision as to whether to accept or continue with the tasking rests with the pilot in command of the relevant aircraft. The pilot in command is responsible for the safety of the flight and crew. They make the final decision as to whether and how aircraft taskings are carried out. Your Honour, the evidence indicates that on the 23rd of January 2023, Ian Macbeth, as pilot in command of B1, 23 January 2020, Ian Macbeth, as pilot in command of B134, exercised his authority in determining whether to proceed with taskings. B134 completed, as Your Honour knows, several circuits over Adaminaby before electing to reject the tasking and not drop retardant over the fireground due to visibility issues. Once B134 arrived at the Good Fireground and identified a target area for the jettisoning of fire retardant, B134 completed 3 circuits of the target area at about 1,500, 500 and 1,000 feet AGL above ground level before completing the retardant run or the drop. Your Honour, the third and final circuit ahead of the jettison run, which is referred to as the dry pass, is targeted to be completed at 300 to 500 feet AGL, some 100 to 300 feet AGL above the jettison run and at a faster airspeed than the jettison run. The altitude of the dry pass, being higher than the jettison run, is to provide a safety margin for pilots given the increased risks of low-level flying. Your Honour, the ATSB assessed that the lower circuit height of 500 feet AGL may not have been low enough for the B134 crew to have accurately assessed conditions at the drop height and any localised terrain or fire effects, particularly given that these circuits were above the height of the ridgeline parallel to the retardant drop line. Mr. Gallagher's experience from Coulson Aviation is that there is no significant difference between conditions at 500 feet AGL compared with 200 feet AGL. B134's three circuits, that's at 1500, 500 and 1000 AGL, of the target area ahead of the jettison run was consistent with the training and procedures of Coulson Aviation. E. Macbeth, as your Honour knows, was an experienced pilot, having completed over 900 tanker drops. Your Honour heard that ahead of the 2019-2020 bushfire season, Mr. Macbeth had completed training, flights where he dropped water instead of fire retardant at around 200 feet AGL. That said, Your Honour, in our respectful submission, it is fair for Your Honour to draw the inference that having elected to undertake the jettison drop after completing the three circuits of the target area, E. Macbeth and perhaps the crew of B134 reached the conclusion that it was safe to proceed with the tasking. Can I just briefly deal with some minor tensions in the submissions in relation to particular factual matters, none of which, in our respectful submission, will impact Your Honour's formal findings or Your Honour's basis to make any particular recommendations. Can I firstly deal with the submissions of the RFS, and in particular paragraph 8 of the RFS's submissions, where there's some faint criticism of those assisting Your Honour in relation to the timing as to when B134 and B137, that is the Boeing 737, another LAT, were tasked on the 23rd of January 2020. Can I say this, Your Honour, that from a review of the evidence as a whole, it is inconsistent as to the precise timing. I think, looking at it fairly and objectively, what could be said is that at about 11 o'clock on the morning of the 23rd of January 2020, a decision was made to task B134. Can I invite Your Honour to make a note of some references in the evidence that assists on that question. Your Honour has before Your Honour a statement of Mr. McKechnie, Deputy Commissioner, and in his second statement, paragraph 32, and that's found at tab 29 of the brief of evidence at page 682-7, that Mr. McKechnie in that statement says, and I quote, "I believe I had approved the tasking of the two LATs to the Adaminaby fire sometime during the morning of 23 January 2020 and prior to the red phone call at 11:03 hours." And then Your Honour has the Richmond Air Base Manager logbook, and that, Your Honour, is found at tab 44, page 781, which records at 10:49 a.m, retask B134 to Adaminaby ASAP, no bird dog, windy conditions, only do what they can do safely. And then again, just on this question of the timing of the tasking, Your Honour has the transcript of Deputy Commissioner McKechnie, which is found at page 1209, lines 11 to 15. Question: you record in your second statement, Mr. McKechnie, that you believe that the conversation may have taken place before there was the red phone call at about 11:03. Answer: correct. And then Your Honour has the red phone call, and that That's the phone call from Mr. Jim Durant, who was the incident controller from the Cooma Fire Control Centre, and you have Commissioner Rogers saying, and this is at 11:03, let's not wait till the bird dog gets down there. That recording, Your Honour, is found at tab 29, or the transcript of that recording is found at tab 29, page 682-19. And then, additional to that, there's further transcript of Deputy Commissioner McKechnie at transcript page 1210, lines 6 to 12, where Mr. McKechnie is asked, question, in circumstances where you're the state operations controller, should it not have been your decision to task or dispatch a LAT as opposed to Mr. Rogers? Answer, my recollection was that in the period of that call, that's 11:03, leading up to it, and actually during the call, that's what I was actually doing, was tasking them with the state air desk. Just finally on that topic, Your Honour, can I, without reciting it, give you some further evidentiary references? There's the further transcript of Mr. McKechnie at page 1210, lines 20 to 41. Then there's the evidence of Mr. Crothers, who was on the state air desk, at tab 30, page 682-27, which has recorded at 11:10 verbal direction given to him to send 2 LATs to Adaminaby. We have also his transcript at page 987 to 988. That said, Your Honour, as I said at the outset, there's some inconsistency in relation to the evidence, but the long and the short of it, nothing really turns of it in a material sense as to the timing. Can I then deal with paragraph 13 of the New South Wales Rural Fire Service submissions? And this turns on an inference in relation to how it was. It seems that B134 were in communication with Mr. Finstead, who was the Air Operations Manager at the Cooma Fire Control Centre. The New South Wales Rural Fire Service, Your Honour, contend that an available inference to be drawn arises from the ARENA dispatch. That's the electronic system used by the state air desk in relation to recording taskings, that from that dispatch that B134 were given Mr. Finstead's telephone number. In relation to that matter, we've got the evidence, tab 93, page 1253, where E. Macbeth told Mr. Dugan he was only given the Fire Common Traffic Advisory for frequency, radio channel TG45, and the coordinates of the fire. In that same statement, that's the statement of Captain Dugan. Captain Dugan told Macbeth to call Cooma Air Ops on TG45 for his contact. We know that the ARENA dispatch was sent by email at about 1:13 p.m. That's found at tab 50, page 793, 2 minutes before the incident. And of course, Your Honour, has the Airbase Manager's logbook at 10:49, which includes the contact number of the Air Operations Manager, that's Mr. Finstead. That's tab 44, page 781. Of course, as was revealed throughout the hearing, that there's 1 digit difference from the ARENA dispatch and what's contained within the log. It includes a 1 instead of a 2. That said, Your Honour, there's 2 competing inferences. What is clear that it seems at least that B134 was in direct communication with Mr. Finstead, Air Operations Manager at the Cooma Fire Control Centre. How that was initiated remains unknown, and in circumstances where there's 2 competing hypotheses of equal probability, it's our respectful submission that Your Honour does not need to resolve that particular question other than to make a finding that they spoke to each other. Coming, if I may, to paragraph 19 of the New South Wales Rural Fire Service submissions, it's contended that the grounding of local aircraft by the Coomera Fire Control Centre was due to poor visibility. In our respectful submissions, the evidence is overwhelming that it was not just due to poor visibility, but was in fact due to poor weather conditions, namely high winds. And the most telling evidence of that is the red phone call at 11:03, where Ben Millington, who was the then Deputy State Operations Controller, says aircraft are currently grounded due to wind and visibility. Transcript of that, Your Honour, is found at tab 29, page 682-18. Your Honour also has the examination of Deputy Commissioner McKechnie, transcript page 1211, lines 1 to 4, where he's asked question, were you informed throughout the course of the day that local aviation assets attached to the Coomera Fire Control Centre had been grounded due to poor weather conditions and poor visibility? Answer, yes. There's also the examination of Mr McGuffig, transcript page 1153, lines 23 to 26. Question, was that because of the local conditions were such that local air crews were not prepared to fly because the conditions were too unsafe because of high winds and poor visibility? Answer, that's correct. And Mr McGuffig, Your Honour, was the Deputy Incident Controller at the Coomera Fire Control Centre. The two I ceded to Mr Durant. Your Honour, that I think deals adequately with some tension in relation to the evidence, but as I've submitted, I don't contend that it has any material bearing on the formal findings that Your Honour is required to make. Can I just deal with one matter? In our written submissions, Your Honour, it's paragraph 103, page 19 of the document, and in particular, subparagraph A relating to flight risk assessment. The New South Wales Rural Fire Service quite rightly takes issue with paragraph 103, subparagraph A. It's addressed in their written outline of paragraph 11. Your Honour, we accept what is said by the New South Wales Rural Fire Service in paragraph 11, and I do not rely upon, and accordingly withdraw paragraph 103, subparagraph A. Can I now address Your Honour on the question of recommendations? Your Honour, as part of Your Honour's inquiry, looked at the tasking of large air tankers and the communications and information provided to large air tankers. Those assisting Your Honour formulated a number of recommendations, and as a result of the formulation of those recommendations, a response has been provided by the New South Wales Rural Fire Service contained within their written outline. And it may be convenient if I invite Your Honour to turn up the New South Wales Rural Fire Service written outline of submissions, commencing at page 8 towards the back of the document. Proposed recommendation 1, Your Honour, the New South Wales Rural Fire Service agrees in principle with that proposed recommendation, and as Your Honour will see, it is anticipated that an electronic flight risk assessment prototype will be available sometime this year. Your Honour sees on page 8 of the New South Wales Rural Fire Service Submissions Recommendation 2 Your Honour will see that there are some commentary in relation to that, and a revised recommendation 2 is suggested by the New South Wales Rural Fire Service in paragraph 28 on page 9 of their submissions. Your Honour, I'm instructed to accept that revision. Similarly, in relation to recommendation 3, some slight variation is proposed by the New South Wales Rural Fire Service in paragraph 29 on page 9 of their outline of submissions. And again, I'm instructed to accept that proposed variation. In relation to recommendation 4, we note what is submitted by the New South Wales Rural Fire Service in paragraph 30 on page 9, and as a result of that, I do not press recommendation 4. In relation to recommendation 5, foot of page 9 and over to the top of page 10, there's some slight variations proposed in the language of recommendation 5, and can I indicate to Your Honour that I'm instructed to accept each and every one of those proposed variations, which are articulated in paragraph 31, sub-paragraphs A through to E inclusive. Similarly, in relation to recommendation 6, Your Honour will see that the New South Wales Rural Fire Service agrees with that proposed recommendation. In relation to recommendation 7, Your Honour will see that the RFS agrees with that particular proposed recommendation with some minor amendments, and I can indicate to Your Honour that those who instruct me accept those proposed amendments, which is dealt with in the top of the page at page 11. In relation to recommendation 8, Your Honour, we have considered what the New South Wales Rural Fire Service has submitted in relation to recommendation 8, which is contained in paragraphs 34 to 37 of their outline, and having regard to those matters, my instructions are to not press recommendation 8. For reasons which are exposed in the written outline of submissions, the New South Wales Rural Fire Service has addressed recommendations 9, 12 and 13 collectively, and then have submitted that there should be one recommendation which covers the field so far as those assisting Your Honour is concerned in relation to proposed recommendation 9, 12 and 13, and Your Honour sees that in paragraph 40. I'm instructed to accept that proposal, and if Your Honour was persuaded of that position, that would obviate the need to consider our recommendations 9, 12 and 13. Recommendation 10, again, Your Honour will see in paragraph 42 of the New South Wales Rural Fire Service submissions that they agree with that proposed recommendation in principle, subject to some minor amendments, and Your Honour will see those at the top of page 13 of the outline. Your Honour, I'm instructed to accept those revisions. In relation to recommendation 11, at this time I wish to reserve my position on recommendation 11 until I've heard from my learned friend as to what are the technical reasons why it is said that the RFS cannot record all radio bands with aircraft, thereby being in a position to be unable to record radio communications with aircraft involved in firefighting operations. And then finally, Your Honour, in relation to recommendation 14, there is agreement, and we accept that the words training should be replaced with briefings/induction. And Your Honour sees in relation to proposed recommendation 15 that the New South Wales Rural Fire Service agrees with that particular recommendation. Your Honour, before I take my seat, I just want to deal with one matter which arose on the evidence concerning culture. One of the issues that arose was whether the organisational culture and relationships between fire agencies and contracted aviation services unduly influence service demands. Can I say this, Your Honour, in very clear terms? It's our respectful submission that the evidence does not establish that a recommendation directed to the relationship between the New South Wales Rural Fire Service and contracted aviation operations is necessary or appropriate, and that, importantly, Your Honour, there is no evidence before Your Honour to conclude that undue influence or pressure impacted pilots on the 20th of January 2020. Finally, Your Honour, can I say this publicly, as I said when I opened the inquest, that those assisting Your Honour again wish to express our condolences to the families of Rick, Paul and Ian, particularly Virginia, Bodie and Noreen, and the children of Rick, Paul and Ian, and all of their friends and loved ones for their loss. Can I also publicly express our sincere gratitude to those who have aided and provided information to the team assisting Your Honour in relation to the inquest before Your Honour and in relation to the inquiry into the cause and origin of the Good Fire. May I please, Your Honour?
Thank you, Mr. Castleton.
Oh, sorry, I'm just reminded of one matter. In recent days, Your Honour, those instructing me have been provided with two documents from the RFS. One is titled Operating Guidelines for Air Tankers Operations. It was ostensibly approved by Deputy Commissioner Peter McKechnie on the 13th of February 2023. And the second document, titled Operational Management Procedure, Rejection of an Aviation Dispatch Tasking, and ostensibly it bears the date of February 2023. Can I provide those to you? I understand that very recently copies were circulated to my learned friends. If they could be marked Exhibit 66, form part of Exhibit 66, and take the tab 87A for the operating guidelines for air tankers and tab 89A for operational management procedures.
Yes, thank you.
Your Honour, for reasons that remain unexplained, these documents were not before Your Honour when Your Honour heard these matters in March of this year. There are some differences between these documents and policy documents that relate to the tasking of LATs that form part of Exhibit 66. And I invite my learned friend Mr Newton on behalf of the New South Wales Rural Fire Service to provide an explanation as to why these were not before Your Honour in March of 2023 when relevant witnesses were called and could have given evidence in relation to those particular policy documents.
Are you in a position to do that?
Your Honour, to be honest, I'm not. Other than this, the way that it has arisen is that in the course of the instructing agency giving instructions as to the written submissions that were prepared, there was a reference to the policies, and then we were told in the course of that those policies had been updated, and upon that occurring, they were provided to Mr Castleton's instructing solicitors. I think presently my understanding is it's just through an oversight of dealing with all the various pieces of information that the amount of information that we've had to be dealing with. So beyond oversight, really, I don't have any further explanation. If Your Honour wants a more detailed explanation, then it will be something which will have to be addressed by getting instructions and then writing a letter to Your Honour's instructing to the counsel assisting instructing solicitors, and I'm happy to facilitate that.
Thank you, and I'd appreciate if that could be done, Mr Newton.
Yes, Your Honour.
I'm indebted to my learned friend, and just for completeness, Your Honour, Your Honour has also before Your Honour the written submissions on behalf of Coulson Aviation, and can I indicate that in relation to those assisting Your Honour's proposed recommendations, which numbered 1 through to 15, that there's general agreement or support on behalf of Coulson Aviation, other than in relation to recommendation 14 and 15, to which I understand they remain silent on.
Thank you, Mr Castleton. Does anyone have anything they'd like to raise at this stage before we finish?
Your Honour, that just in terms of I was going to just address the minor factual discrepancies that
Yes,
Mr Castleton raised. In terms of the first one that he raised was the submission that we made at paragraph 8 of our written submissions, and I think that probably we're at slight cross purposes in terms of what the factual issue that paragraph 8 of the written submissions that we were attempting to raise. There's no dispute that there was a decision, I think, by Assistant Commissioner McKechnie shortly before 11 a.m. to pick up the words of counsel assisting submissions to task B134 and 137 to Adam Mitterby. It was the fact that it was the suggestion that was a tasking without a bird dog at that time. As is made clear, probably the clearest point is the red phone call that Your Honour's listened to, and there's a transcript in the evidence. It was during that call that there was a decision made to send the 2 lats before the bird dog. So even at that stage, it wasn't without a bird dog. It was before the bird dog because they could get there more quickly. Whereas you'll recall that initially there was a suggestion the bird dog was going to go and do a reconnaissance and then the lats would follow. So it's only a fairly subtle factual dispute, and really it seems that the decision to go before the bird dog was made in the course of that red phone call. The second matter that counsel assisting raised was, bear with me, it was the paragraph 19 of our written submissions and the suggestion that the local assets were grounded, the suggestion in our written submissions that the local assets were grounded due only to visibility issues, and that is just an oversight in our submissions. That was not my intention. So that I accept that it was visibility and weather issues, and Mr. Castleton rightly drew Your Honour's attention to the various references in the evidence to that. But again, ultimately, what was really, again, it's a relatively subtle point about, there was a lot of talk before, Your Honour, about task rejection, and that the significance that task rejection had, I think, was particularly to Mr. Duggan. But it may be a distinction without a difference, to use Mr. Castleton's words, in relation to another issue. But factually, what occurred was the planes at Cooma did take off, so they didn't reject the tasks. They took off, they flew over Adaminaby, and then they flew back due to weather conditions, which in essence was what was occurring later which is in essence what B134 did as well. It went to Adaminaby, it assessed the weather conditions, and then determined, having regard to them, that it wasn't going to do the drop there. So it's a relatively subtle point, and it doesn't detract from the RFS's agreement to the recommendation that where either there is a rejection or indeed a grounding for weather-related reasons, that's information which now ought be communicated at the time of tasking, and that's captured by the agreement. That then takes me just to a point which isn't addressed in the written submissions, but it's a matter that, and that was through oversight, and it's a matter in terms of counsel assisting urges Your Honour to accept the evidence of Mr. Duggan in contrast to the evidence of Mr. Harder in relation to whether or not Mr. Harder told Mr. Duggan that the reason for the local aircraft being grounded. With respect, I'm not urging Your Honour to accept Mr. Harder's evidence. Rather, this is an example where Your Honour ought not resolve what is ultimately a factual issue, not determinative of the information that B134 had, which is really the relevant matter for Your Honour. And I say this because Mr. Duggan's recollection of what was important to him and information that was important to him is a matter which he was doing a month after the event. He was clearly doing it honestly, and I giving evidence honestly in the witness box. But experience tells one that people's recollection, even a month after the event, may fade, and certainly sometime later. And there's an additional element here in that there seems to be communication over a radio where information's given from one end, but not necessarily received at the other end. So it may be they're both right. And that's why, Your Honour, I'd say in terms of a factual dispute, it's one that Your Honour doesn't need to resolve. And there are, in terms of just the unreliability of people's recollections, or perhaps unreliability is too strong a way of putting it, but the way that recollections can be influenced by perception. There was a particular example of Mr. Duggan's evidence in relation to a conversation he had with the airbase manager. And in his statement, which he said something to the effect, it was at paragraph 125 of Mr. Duggan's statement. No, excuse me, that's not the right reference. Paragraph 47 of Mr. Duggan's statement, which was at tab 93 of the brief, he had a recollection of a conversation with the Richmond Airbase manager where, in essence, his evidence was he told the Richmond Airbase manager that due to bad weather, he was placing himself on hold and he didn't want to return to Adamitabie, and that the airbase manager objected to that, and that caused him to be frustrated. Now, I have no dispute that was his honest recollection at the time that he made the statement. But when Your Honour had the benefit in that case of a recording of what in fact happened, that recording is in the brief at tab 64G, and it's subtly different, but it's importantly different, because what Mr. Duggan did say is, we're putting ourselves on hold. The airbase manager said, would you be able to go to Canberra and refuel and go back to Adamitabie? And Mr. Duggan said, no, the weather's not appropriate for that. We want to come home. And the airbase manager's response was something to the effect of, okie dokie. And it was clear that he wasn't objecting to Mr. Duggan's decision making. In fact, he supported it in essence by saying okie dokie or something to that effect. So this is not an example. I reiterate that, having listened to Mr. Duggan in the witness box, he was clearly an honest witness. He was very credible, and someone who was doing his best to recall events and giving genuine evidence. It's just that where there are these minor factual inconsistencies with my respectful submission, another witness, Mr. Harder, who was doing the best he could and giving genuine evidence, where it's not necessary for Your Honour to resolve it, then in my respectful submission, that's the appropriate course to adopt. Those are my submissions, Your Honour.
Thanks, Mr.
Excuse me. Sorry, I hadn't addressed the one matter, the recommendation. In my written submissions, or our written submissions, I've articulated the reason for the RFS objecting to recording of all radio recordings as technical reasons. It is true, I understand there are technical difficulties in recording some radio recordings, although they're beyond my ability to articulate them to Your Honour. But having obtained further instructions on that point this morning, the reason why Mr. Harder's recording was not recorded on that day was he was not in fact in the Cooma Fire Control Centre. He was in a tent next to the airbase. So the real reason for opposing Your Honour's recommendation is in fact already occurring, that all radio messages in and out of a fire control centre are recorded already, including radio messages from a plane if they come into the fire control centre, because that is on the government radio network and that's recorded. As I understand it, the network which Mr. Harder was using was one which is overseen by a different organisation. What is it? Air Services Australia. And that is not, it is not possible for the RFS to record that one, because it's not actually in their premises. They're using a radio, and because it's being Air Services Australia is in essence in control of that network, then that's what prevents the recording. Now, whether they can and have recorded it is something that I don't know. There is some evidence, though, that they have recorded other recordings from air traffic control, for example, to aircraft, and that's in the brief. Thank you.
Thank you, Mr. Newton. Yes, Mr. McPherson.
Thank you, Your Honour. I'm going to try and demonstrate the Victorian efficiency with these submissions, Your Honour, in relation to several of the matters.
We might be here tomorrow then.
There we go. Your Honour, in relation to the submissions of the ATSB does not seek to be heard in relation to any of the matters raised by the Rural Fire Service in relation to any of its submissions. And in relation to the matters raised by Coulson, I wish to address only some discrete issues arising in a headline way the way in which counsel assisting has properly put forward various recommendations, the ATSB does not formally support or detract from those recommendations, but the way in which those issues have been presented means that, respectfully, a number of the matters that are raised by Coulson do not need to be factually determined by this court. That can be viewed as one of two ways. The first is that the ATSB was not a primary actor involved in the events the subject of this inquest, and it's not part of the function ordinarily of this court to conduct some form of de facto audit or approval process in relation to another investigator's process after the event. Alternatively, another way of looking at it is that matters raised by Coulson in their submissions, which are not the subject of any form of positive assertion of findings of fact or recommendations by counsel assisting, are really disputes adversarial inter partes, which don't need to be resolved by this court. That's another way of looking at the same problem. Under cover of that generalised submission or objection, can I make the following brief submissions, but I'll do so largely by reference to 10 points, as opposed to seeking to elucidate the evidence. At paragraph 8 of the submissions from Coulson, there's a suggestion that the ATSB investigator has positively asserted that the lowest circuit of 200 feet ought to have been adopted. There is no evidence in support of that submission. The reference made by counsel assisting is as correctly identified in the closing submissions today. I'd otherwise note that in counsel assisting submissions, the evidence at paragraph 27 of their submissions that there was a reconnaissance low circuit done at 300 feet. There are some generalised criticisms of Ms. Henwood and the way in which she gave her evidence, which I won't repeat. The point I'd like to make in headline in relation to the ATSB and its report is that it is actually an institutional report of the agency. It's not Ms. Henwood's document in her own sense. She's obviously the person that is giving evidence before the court and explaining the content therein. She did lead a multidisciplinary team. That was made clear at pages 8 and 9 of the slides and pages 937 to 938 in relation to her experience. And that experience included drawing on people from the aviation field, including a person who had 16 years of military operations flying a plane. So it's not quite as blunt as to suggest at paragraph 28 of the submissions that from Coulson, that Ms. Henwood had no experience herself in relation to being a pilot, which is obviously true, but it was a multidisciplinary team overall. There are then 4 discrete issues in relation to matters concerning the pre-flight risk assessment tool, the wind shear detection system, safety management systems, and then simulator training. And ideally, Your Honour, all I am going to do in relation to this is to give you pinpoints from the ATSB report, but also from the transcript. And those documents and that evidence will read for itself, rather than simply having the gloss from Coulson about the cross-examination. It should be looked at contextually overall. With the pre-flight risk assessment tool component, there is no suggestion in the ATSB's report that the issue of whether or not the rejection of the tasking, however we want to call that, was in and of itself going to be somehow a contributory factor overall in relation to this matter. It was part of the cumulative mix that the ATSB identified ought to be considered as part of the framework for assessing risk. Now, the re-examination of Ms. Henwood at page 983 explains the reference and the way in which that tool would have operated. It's not a suggestion that the tool needs to be updated mid-flight. It's an assessment process which is dynamic in the sense that it's done at the start of the flight, achieves a score. That score then enables a certain element of risk to be assessed at the start of the flight, and as particular additional elements are made known during the course of a task, that may impact upon the pilot who maintains autonomy in relation to whether or not to accept or reject the tasking, is going to continue in that form. And the tool in question, the subject of that re-examination, is tab 100, pages 1290 to 1292. In relation to the safety management systems, I'll just ask Your Honour to have full regard to pages 42 and pages 60 of the ATSB report. In relation to the wind shear detection system, this is a matter which is not identified by the ATSB as being contributory, nor is the wind shear training component identified as being a contributory factor. So the submissions insofar as they're made by Coulson, which suggests that don't have that characterisation. Otherwise, Your Honour, could I ask Your Honour to look at page 951 of the transcript of Ms Henwood's evidence and page 66, 75 and 76 in relation to the wind shear training, simulator training, which has been adopted by Coulson overall. Pardon me just a moment, Your Honour. Your Honour, just finally on the issue of the definition of wind shear versus the tailwind direction component, there is effectively, in my respectful submission, no meaningful difference between what has been identified by the ATSB and what has been identified by Coulson in the submissions. And in that regard, Your Honour, could I ask Your Honour to have express regard to page 974 of the transcript, in which my learned friend Mr Omani cross-examined on the premise of the definition of wind shear incorporated the very thing that he's agitating for an amendment in the circumstances. So I just don't see there being any real meaningful difference between the parties on that discrete issue in any event. I'd otherwise refer to the full findings at page 59 of the ATSB as to the concept of wind shear, which was drawn from the Bureau of Meteorology definition at page 19 of the ATSB report.
Thank you, Mr McConnell.
Your Honour, I can indicate I won't be addressing in accordance with the traditions of the Victorian bar, but I don't propose to be very long. There's 3 or 4 points that I wish to make at the outset that can be dealt with very briefly, and then there's a handful of more substantive points that emerge from the written submissions. In terms of what Learned Counsel Assisting has submitted as to the cause of the accident and the substitution of a wind event in the relevant text from Counsel Assisting's submissions, we embrace that, and I just wanted to make that clear from the get-go. The second point that was also addressed by Counsel Assisting that I wanted to address on is the evidence before the court about cultural issues, both within the RFS and within Coulson, and in terms of the way they segued or parlayed with one another. That evidence is, of course, the evidence of Mr Polkinghorne, that the findings he arrived at are as serious, we submit, as they are without foundation. And we respectfully embrace the approach that Counsel Assisting urges in relation to them, that they would be, in effect, put to one side. That they were conclusions, we respectfully suggest, that were looking for some evidence to support them, and they never found it. Whatever they were based upon, it wasn't any probative evidence before Your Honour's court, and it wasn't any analysis or scientific work that was undertaken by the author. It was speculation and should be treated as such, and we respectfully embrace what's been said on that front by Counsel Assisting. In terms of the approach that Coulson's taken to the process that's unfolded before Your Honour, at all times Coulson has constructively engaged and sought to assist and is in any way possible. Consistent with that, every effort was made to have Mr Duggan give evidence remotely from Idaho, and of course Mr Gallagher came out and gave evidence in person, thinking it important to be in Your Honour's court, having regard to the subject matter of this inquest and wanting to be here, amongst other reasons, for the relatives and for the victims themselves. The fourth point to just raise quickly at the outset is the issue that's arisen this morning in terms of who's to be believed as between the relevant RFS witness and Mr Duggan. Could I just indicate to Your Honour that on behalf of Mr Duggan, who I should have indicated at the outset I appear for as well, we respectfully embrace and urge the position contended for by Counsel Assisting. Mr Duggan came before Your Honour's court as the most compelling of witnesses who had granular recall of the events in question and spoke in the most coherent way about the way in which those things and matters unfolded. Could I, in that regard, commend to Your Honour a particular passage of transcript that's found at page 1025 of the transcript, lines 5 through 10. There, in relation to the relevant conversation, the question is quite fairly put to Mr Duggan by senior counsel for the RFS as to whether or not he may have misremembered what was said in the relevant conversation. And perhaps if the answer stands for anything, it's the absolute clarity in the witness's mind of the version of events he has relayed? Absolutely not, was the answer. No. That was the most important thing that I've taken away from this whole thing. And Your Honour will read on what is said in the balance of that answer. None of that is surprising when one pauses to remember, Your Honour, how significant that conversation was and that evidence was in the context of the chronology of events that brings all of us before Your Honour's court. And we, against that backdrop, commend the account of Mr. Duggan, and if one account is to be favoured over another, we suggest respectfully that it would be Mr. Duggan's. Can I turn then to say, in relation to the substantive submissions, to a large extent, Coulson relies upon what we've committed to in writing. There are three brief issues I want to address on. One is the FRAT and the evidence around that. The second is the safety management system. And the third is wind shear related risk management or mitigation. In relation to the pre-flight assessment or risk assessment tool, we've tried to address that in detail at paragraphs 29 through 41 of the submissions. Your Honour will recall the suggestion emerges from the ATSB's report, which is Exhibit 66, that the lack of a formal recorded FRAT played a causative role in respect of the crash in question. A serious finding. Your Honour does not need to hear me to say that to realise when one looks at the relevant finding as articulated in the report. As we indicate at paragraphs 33 and following of our submissions, that is a finding which respectfully we submit is just not available, not viably available on the evidence before the court. And there's a number of reasons for that. For one thing, it assumes that the most valuable information that could have been factored in to any pre-flight risk assessment, that is, as to the rejection of the bird dog and as to the fact of local assets not taking off and not flying on the day in question, could have been included in any such formal pre-flight risk assessment. And of course, as we've indicated by reference to the evidence of paragraphs 33 and 34 of our submissions, that was never going to be the case. The fact of the bird dog rejection occurred at 12:04 p.m. on the relevant day, 1 minute before takeoff of B134 at Richmond. And of course, Your Honour's heard a great deal of evidence about the lack of information flow to Richmond or the pilots when it came to the activities or non-activity of local aircraft. That is, we respectfully submit valuable information that would never have formed any part of any such FRAT. The second issue is that, of course, if such a FRAT had been completed before flight on the relevant day, it would have been overtaken by events almost immediately after takeoff, Your Honour. The evidence on that is clear. That FRAT would have been directed towards risks associated with the Anonymity fire ground shortly after takeoff. Of course, the flight was on-tasked or retasked to attend the Good fire ground. It's important to stress that that was not an outlier in the context of these kinds of activities. The evidence makes clear, in particular, the evidence of Mr. Justo Coward and Mr. Duggan, that was something that pilots regularly faced in the context of aerial firefighting activities, that upon takeoff, the intention was to attend one fire ground and undertake certain activities in respect of it, but invariably or often it was the case that they would get retasked once they were up in the air. The third problem is that the approach of the ATSB doesn't recognise what we respectfully submit multiple compelling witnesses, both with singular voice on, before Your Honour, and that is that any such formal FRAT would have recorded in writing what was always done anyway. Multiple witnesses, Mr. Gallagher and Mr. Duggan, gave compelling evidence on that score, Your Honour, and not a single probing question was asked of either of them. Ultimately, we respectfully submit that the suggestion that the existence of a FRAT would have played made any causative difference when it came to the events on the day in question is one which this court would comfortably reject. The second issue is the safety management system analysis of the ATSB. We addressed that in detail, including by reference to the evidence at paragraphs 42 to 52 of our written submissions. We respectfully embrace the approach that counsel assisting urges on this issue, that no findings or recommendations be made. We add to that position urged by counsel assisting the following, that if any finding was to be made, it would be along the lines that there has been, at all relevant times, an extensive, expansive system in place directed towards risk management and safety culture at Coulson, that system started with recruiting, identifying and employing some of the leading pilots and crew in this space globally, promoting a culture of interaction between all stakeholders which had at its heart a focus on risk management and risk mitigation, as well as risk identification, and a culture that promoted learning and a constant process of updating procedures and protocols by reference to lived experience, literally on a day in, day out basis. Your Honour will recall that the evidence revealed daily safety calls which had at their heart a focus on developments of the last 24 hours, what could be learned from those developments in terms of, amongst other things, risk identification and risk mitigation, and a forward-looking what was to be done in the next 24 hours and how could that be most effectively and safely attended to. One of the troubling aspects we respectfully suggest of the ATSB's report on this issue, Your Honour will see what we say about it at paragraph 46, is the finding that there was a focus when it came to risk management on discussing maintenance issues rather than operational issues. That is clearly the upshot of the author of the ATSB report concluding that because the records show that there was wide discussion or relatively wide discussion of maintenance issues, the inference was drawn that somehow employees weren't encouraged to speak up about operational issues. That we respectfully suggest is an approach which must be rejected. It is, we've committed to a detailed position in writing on this, Your Honour, because it's an affront, we suggest, to the relevant officers and employees of Coulson. It's not supported by the evidence, perhaps most importantly. The evidence reveals that there were daily calls that comprised and promoted amongst the employees and stakeholders discussion of all manner of issues: maintenance, operational, risk identification and risk mitigation. Your Honour sees what we say about that at paragraph 48 of our submissions, and we've extensively referenced the evidence that supports that. Perhaps most tellingly, Your Honour, that the very contemporaneous evidence before Your Honour's court about the content of those calls in the period leading up to the incident reflects that they were discussing, amongst other things, the risks of flight in this space in respect of this fire and these operations, including as to terrain and managing those risks. Ultimately, Your Honour, if any findings were made on this topic, it would be that regrettably the conclusions drawn by the ATSB are not tethered to the information and evidence available, or B, that there was at all times in place on the part of Coulson Aviation an SMS system that was fit for purpose. And Your Honour has seen what we've said about that. The final topic, Your Honour, relates to wind shear. Your Honour will recall there are two aspects of the ATSB's report in this respect. The suggestion is, in effect, that firstly, the lack of a wind shear detection system, and secondly, the lack of wind shear related training somehow contributed to the crash of B134. We respectfully submit that that is a worldview that is problematic in the extreme, and that no findings should be made in respect of it at all. That there are three issues, at least, arising in relation to this line of country for present purposes. The first is that the ATSB findings are based on and wholly tethered to a series of documents, none of which relates to aerial aviation firefighting, all of which relate to more orthodox traditional flight in and out of airports. That's the first point. The second and related point is that the systems in question, the wind shear detection systems, as Your Honour's heard, and we've identified the relevant evidence in the transcript in our submissions, they are forward-looking systems that rely upon straight line travel to work out what lays ahead for a flight. And they have real work to do, valuable work to do, in the context of planes arriving at airports or departing from airports. I only need to say that, Your Honour, to see or to understand how far removed the context of aviation firefighting is from an airport-like context. Your Honour has heard about the process of reconnaissance flights, of orbits. Your Honour has seen from the maps the zigzagging of certain flights at different times to get an appropriate line of sight on the fire ground. In that context, as Your Honour heard from multiple witnesses, the reality is those systems have no work to do. They don't have forward-looking particles to latch onto. But of course, Your Honour, even if they did, another problem emerges. The evidence is clear that the way in which those systems work relies upon moisture in the atmosphere. And Your Honour didn't need to hear it, I'm sure, from witnesses, but Your Honour did hear it, that one thing that typically is lacking in the air immediately above a fire ground is moisture. So the very particles that this kind of system relies upon for its efficacy are starkly absent from the operating environment in question here. And of course, no regard is had to that, regrettably, in the ATSB report. The only other things to note on this topic are there's no evidence before Your Honour as to whether, as counsel assisting rightly identifies, there's no evidence as to whether there is any system capable of being fitted to the plane type in question, the C-130. There's no evidence as to the cost of, if it could be done, what the cost would be and what the engineering processes might be. Your Honour, to complete the discussion of this topic, if I could just commend to the court the evidence references that we've given from Mr. Justo Coward and Mr. Duggan, who speak compellingly, we suggest, about the fact, on the part of Mr. Justo Coward, gives compelling evidence about the fact that pilots have no better line of sight on wind shear than their own visual and audible cues, and who gave evidence in terms of that being preferable to any wind shear type system. And of course, Your Honour heard from Mr. Duggan that invariably pilots operating in this space are operating in wind shear type environments, such that any alarm system is going off all the time and it can be a dangerous distraction. Could I close, Your Honour, just by making one contextual point that isn't touched upon in our written submissions, but it's an important one that we suggest. Your Honour has in Exhibit 68, Coulson Aviation's response to the draft report of the ATSB. I won't take Your Honour through that. That would take some time, but I respectfully submit that it rewards a careful reading in the sense that what it does do is very carefully and thoughtfully engage with the views and approach of the ATSB by reference to the evidence available on the basis of expertise of aviation firefighting, and provides an indication of some of the problems with issues like wind shear, like the SMS analysis, and like the analysis as to the FRAP. Your Honour will see in the event at Exhibit 66, the ATSB committed to a position on each of those issues, which we respectfully submit has now been the subject of very detailed evidence before Your Honour. That evidence cuts decisively we submit against the ATSB position on each of those issues. Tellingly, the evidence that Your Honour has heard and seen aligns almost completely with the response to the draft report that Your Honour finds at Exhibit 68. Your Honour will have noted that with the body of evidence that did fall that countered the position of the ATSB on each of those foundational issues, not one question was put aimed at defending the ATSB report or trying to overcome the evidence that plainly and directly countered it. We don't criticise the ATSB for that. We actually submit ultimately that was appropriate, having regard to the manner in which that evidence fell. But the final point I want to make is that having seen in the last couple of days the ATSB submissions, there is a clear position advanced there that there's to be no resiling from the position as articulated in the ATSB report. And it follows to simply note in that regard that all of the parties before Your Honour have committed to the importance of learnings from this process and how things might be done differently or better as a result of the evidence and objective matters that Your Honour has heard so much about. The RFS has done that, and Mr Gallagher gave compelling testimony to Your Honour about the importance of at all times introspection and looking at one's own practices and processes to see how they can be improved. Regrettably, the outlier in that regard seems to be the ATSB that has committed to a report, has seen that report take a great deal of water by reference to the evidence that's countered it, and hasn't seen fit to in any way amend it. They are Coulson submissions.
Well, there's two things.
Oh, just one moment, Your Honour.
The transcript correction. We
Yes.
came across that this morning. Yeah, that's all.
Your Honour, just one housekeeping matter that won't take more than 60 seconds, I hope. It's a transcript correction that we've only seen this morning. We would normally deal with that by correspondence. At page 1202, line 18, there's a reference to decline that we think should be a reference to climb. There's a reference to decline power, which should be to climb power, C-L-I-M-B. And contextually, there's on the preceding page, 1201, line 05, there's a reference to climb power that seems to be completely in accordance with that.
Thank you.
They are Coulson submissions, Your Honour.
Thank you, Mr Armani.
Very briefly, Your Honour. So far as that there's a dispute vis-a-vis Coulson Aviation and the ATSB, it's my respectful submission that Your Honour does not need to delve into that area to any great extent, because it does not ultimately bear upon Your Honour's statutory function in relation to the formal findings Your Honour is required to make under Section 81, and then additional to that, Your Honour's power under Section 82 in relation to recommendations. So far as that there's competing submissions in relation to what Captain Dugan has to say, he was or was not told by Mr Harder, can I just remind Your Honour of two things. Firstly, Captain Duggan gave his statement to New South Wales Police approximately 4 weeks after the incident. Your Honour has in evidence the logbook of Mr Harder. It is silent in relation to whether or not he provided the reasons as to why there was no local aircraft in the area. And then, of course, Your Honour has the exhibit, I think it's Exhibit 43A, which was the note, file note, if I can use that term, created by Mr Harder that emerged during his examination. As best I recall, he was unclear in relation to when the relevant aspect of that note in relation to the reason why there wasn't local aircraft in the area was made. At best he could say that the document may have been created about a week or so after the incident, but that he continued to update it up to early May when he had his interview with the ATSB investigators. So I just raise raise those evidentiary matters in relation to the submission by my learned friend Mr Newton about recollections is that we would submit Mr Dugan would have a reasonable recollection of what took place 4 weeks after the incident, and when one has regard both to his written statement and his oral evidence, he was quite firm in relation to that topic. Your Honour, having heard from Mr Newton in relation to our proposed recommendation 11, that is that as it presently stands, New South Wales Rural Fire Service does record communications between fire control centres and aircraft. I no longer press recommendation 11 and accept what Mr Newton says, that so far as the communications on this particular day were concerned, that was a matter within the remit of Air Services Australia. Unless there's any additional matters Your Honour wishes me to address, they're my submissions.
Thank you, Mr Castleton. Take it there's nothing else from the other parties. I would also join my counsel assisting in offering my condolences to the families and friends of Paul Hudson, Ian Macbeth and Rick De Morgan Jr., and also my gratitude to the interested parties and their legal representatives for the approach that's been taken to this inquiry and these inquests. I thank you for your assistance and your cooperation. With that, we'll adjourn.